Hello, dear friends. I'm Pushpinder Kaurman, Professor, University Institute of Legal Studies, Punjab University, Chandigarh. Today, we would be discussing Section 114 of Indian Penal Code. You must be knowing the concept of vicarious liability while studying law of torts, where a person can be made liable for the acts of another. In criminal law, also, a person may not have actually committed a crime, but he can be made liable for the offense committed by other person. Section 34, 114, and 149 of Indian Penal Code are examples of that. Section 114, it falls under the chapter abetment. So before moving to section 114, we understand section 107 that defines abetment. So abetment can be done in three ways. It could be by way of instigation or conspiracy or by way of intentional aid. Section 108 defines who is an abettor, and Section 109 provides punishment for abetment if the act abetted is committed. If offense abetted is committed and no express provision is provided for punishment of abetment, abettor is punished with punishment provided for the offense. Now, suppose A abetted B to kill C, B killed C. So, B is principal offender and he would be liable to be punished under section 302 of IPC. Now, because offense abetted has been committed, so the abettor would also be punished with the punishment provided for offense of murder because no express provision is provided for the abetment of murder. Now we move on to next slide, that is section 114 of IPC, when abettor present when offense is committed. So what we say is that there is a principal offender. Principal offender is a person who actually commits the crime. So, by applying this section, a person who abetted the offense is treated as a principal offender, that he shall be deemed to have committed such act or offense. We read this section. Whenever any person who is absent would be liable to be punished as an abettor is present when the act or offense for which he would be punishable in consequence of the abetment is committed, he shall be deemed to have committed such act or offense. So, first of all, there has to be abetment, and if the person is absent, he would be liable to be punished as an abettor. But if he is present when the act abetted or the offense abetted is committed, he shall be deemed to have committed such act or offense. So we see what are the essentials of section 114 of IPC. There has been prior abetment. The offense abetted has been committed. The abettor was present when the offense was committed. The abettor shall be deemed to have committed the offense. We take examples for that. A instigates B to kill Z. A was in Chandigarh and B killed Z in Delhi. B would be liable under section 302 of IPC. A would be guilty as an abettor and applying section 109 would be liable to be punished under section 302 of IPC. B would be treated as principal offender in this case and A would be liable as an abettor. Now, when we come to section 114, We take this example. A instigates C to serve poison food to Z, but by mistake serves it to Y. So he has instigated C to give poison food to Z, but C by mistake serves it to Y. Now, to ensure killing of Z, if A accompanies Y and was present at a place where C served food to Z, by legislative fiction, A shall be deemed to have killed Z. Now we understand it with simple example. A wants to kill some Z. He gives a poisoned apple to a child C. He accompanies the child where Z is standing and tells him that you give this poisoned apple to that uncle standing in red t-shirt. Now he ensures that the child gives that poisoned apple to Z. So here, by legislative fiction, A shall be deemed to have killed Z, although actually it was the child who gave the poisoned apple to Z. Now, what is difference between the first example where we took the example that A was in Chandigarh and B killed Z in Delhi? Here, A was not present when B killed Z. So this case will fall under section 109. But when we talk about this poisoned apple case or poison food case, in the second example, A had accompanied the child and was sufficiently nearby to render assistance if it was a violent crime, like if he would have felt that some kind of assistance is required for killing Z, he was there to provide that assistance, or if he wants to ensure killing of Z and he was present at the place where the child served poisoned food to Z, he shall be deemed to have killed Z. So here A, although did not actually kill Z, would be treated as principal offender. So what is required for applying section 114? Prior abetment plus present at the time of commission of offense. Being present means sufficiently near by to render assistance if the need arises. Now we take few examples to understand better how to apply this section. P, a police officer, present and allowing his junior to torture a prisoner will not be covered by section 114 of IPC. Why? Because if the police officer is absent from that place, it will not amount to abetment. So what is required is both prior abetment plus presence at the time of commission of offense. Another example, P, a lady sitting on a cot 8 yards away from the actual occurrence and she was urging some Z to kill N. She was held to be liable under section 302 of IPC applying section 114 of IPC. Now, what we say is that had the lady been absent, she would have been treated as an abettor. But she was abetting as well as she was present at the scene of the crime. So, applying the essentials, abetment, and presence at the commission of the crime. In case of Dhani versus Emperor, she was held to be guilty of under section 302 of IPC. Now, what is difference between those two illustrations is that here abetment in the case of police officer was done by being present there. He was allowing his junior to torture the prisoner. So had he not been there, it would not have amounted to abetment. So he was providing assistance by being there and allowing the person to torture. So section 114 IPC is not a charging section. It is read with section 109. Now we come to difference between section 34 and 114 of IPC. Section 34 of IPC, it deals with common intention. By common intention, we understand prior meeting of minds plus some kind of participation is must. Under 114 of IPC, prior abetment plus mere presence is required. There is no requirement of any kind of participation. Section 34 of IPC, here common intention cannot be found with a child or a person of unsound mind. But in case of 114 IPC, there can be abetment of a child and a person of unsound mind. And if the person who abetted the offense was present at the place where offense abetted was committed, he would be liable for the offense as a principal offender. So scope of section 114 IPC is wider than that of section 34 of IPC. Thanks friends for watching this video.